go to that.
Thank you.
I briefed 4 issues for this court to review. I'll primarily focus on the top 3, the 4th issue being the sentence, excessive sentence. I'll leave that to the briefs. I think that's pretty straightforward. But going to the 3 main issues, we have the issue with the forensic interview coming in under statute TCA 247123, where there's a bunch of check marks that a trial court has to have in a pretrial hearing to make sure that a forensic interview can come in for a child witness on a child sex case. In this case, we had a pretrial hearing. The young lady appeared for the record, identified herself on the video, identified who she talked to as the Miss Jenny. And then they brought Miss Jenny in, Miss Jenny Stith, and talked about her credentials and where she worked at with Safe Harbor. The judge found that all the particular necessary check marks needed under the statute was met, was pretty specific in going through those rulings in the pretrial motion. But I had objected and advised the court, what are we going to do if this young lady clams up at trial and does not make herself available for cross-examination, which is the other half of that prong that you have to meet. They have to be available for cross-examination. So then you have to look at, what does available for cross-examination mean, or what does that stand for in today's world?
Did you cite any authority in your brief about what that means?
I cited cases. I distinguished McCoy, or talked about McCoy. I believe I cited McMillan. There's some recent cases, McMillan and Rubisky, that talk about what makes it available. On the McMillan case, the difference being in my case versus that case is the defense counsel did not object during the pretrial hearing or at trial to preserve that issue. So he waived it for the most part, and it had come up on a plain error review when it came up on appeal. In this case, I objected at the pretrial hearing. I objected during trial. I incorporated the pretrial motions into the trial. And after the young lady testified for about 15 pages of transcript at the trial, she answered questions as pertain to what her favorite school subject was, or different things that's going on in her life currently. But when was asked specific questions about the elements of the offense, under oath, that's where she claimed it, says, I don't remember, it's fuzzy, I don't want to talk about it. She never effectively said under oath, these things happened. She just said, I don't remember, I don't want to talk about it, and then shuts down. And then at the end of that, I then asked for to have the video struck because she was not available for cross-examination. So I had another hearing mid-trial to have the forensic interview thrown out because she was not available for cross-examination. She did not answer any questions under oath pertaining to the elements of the offense.
I'm having trouble with your terminology because it's clear that she answered questions under oath. She just didn't give the answers you wanted.
She didn't give any answers to the elements, Your Honor, and that's what the proof requires.
And you established that in front of the jury, that this witness was not able to remember any of this stuff. You hit at her credibility by cross-examining her on that.
Sure, but then when does the Constitution come into effect then, Your Honor, for my client? When does the Confrontation Clause under the Tennessee Constitution, the United States Constitution, ever come into effect? If we leave it at that point where the child can come up and just say, I'm not going to answer any questions about the elements, and you're now giving a hearsay statement that's not under oath at a forensic interview safe harbor place, and she gets to say whatever she wants to say at that point, and then all she has to do is come in and say, that's me, and I'm here, and I have to answer any questions, and the jury has to go with that, and my client has no right to confront the witness. You've got to get some teeth to the law. You've got to get some protections to those that are accused of crimes. Otherwise, we have no confrontation clause anymore in the state of Tennessee under this statute. And that's the primary
Isn't that what the statute allows for? That the child is placed or is interviewed, and then that interview is, if it meets all the criteria, is entered into the court as evidence, and that's all that's required. I hear your argument.
So part of the check mark boxes that you have to have at the prelim hearing or preliminary pretrial hearing is that it has to be, they have to show trustworthiness within the interview, okay? So in this particular case, for the first 45 minutes or so of her interview, when they start to get into the meat of what she claimed her father did, she talked about some fondling and some other things and maybe some oral sex on her, on him. And as most interviewers do, they are trained to talk about the first time it happened and then the most recent time it happening being the last time. And so that's what Ms. Stiff did. And in this case, she said the last time was in the master bedroom of her mother's house, and that her mother was probably in the tub and the door was closed, but it was at the house. And she repeated this multiple times. Then there was a short break. The interviewer went out to talk to the detective that was watching on the closed camera on the other room, and they knew from that interview with that mother that morning, because the forensic interview was the same afternoon that the report was made to the police, and the mother said he took her to the new house that he doesn't have keys to, but somehow got in, and tried to rape her at the new house. Talked to her about the new house. And so she comes back in, and she says, and she generally open-ended question, I hear you're about to move, or do you have a new house? She says, yeah. She says, well, did anything ever happen at the new house? And she's like, oh, yeah, he tried to do this to me at the new house, and that was the last time. So how do you have trustworthiness if she says 2 last times? There can only be 1 last time, which is the issue I then brought back up when she finally testified. She did answer that question under oath at trial. Do you agree with me that there can only be 1 last time? And she said, yes. I said, so when was the last time? I don't know.
Well, isn't that confrontation right there?
No, but she didn't answer anything about the elements. She just refused to answer anything other than she agreed that there can be only 1 last time. So that goes to my argument. Then when you go back to when the state says, well, she said that everything she said in the video was true. Everything can't be true, Your Honor. If she says there's more than 1 last time, everything she says cannot be true. So then you get back into those check marks, and now 1 gets unchecked, right? Because she's no longer trustworthy. She can't be telling the truth about everything if she lied about at least 1 last time. And that's the issue we have here, Judge. That's why I made the objection. I went back in and moved to strike that hearing, because she had said there's more than 1 last time. And if we don't do something to give some relief here, then this statute's going to neuter all the constitutional rights of anybody that's accused of this crime in the future. And so that all the state has to do now is put the victim up there, ask them, is that your video? Do you recognize it? And did you tell the truth? And then they don't have to say anything else. And the state normally gets a conviction, because what jury is not going to want to believe a young child that says her father did these things to him? You have to have the confrontation clause there, or else the constitutional rights of any accused is gone, neutered.
Well, I agree with you, but you would still have a right to question her specifically about the video, correct?
I did, and she wouldn't answer.
Whether she artfully answered it or not would be kind of for the weight of the jury, would it not?
But it goes back to that preliminary hearing where you had to check off certain boxes. And because I wasn't able to cross-examine her at the hearing, because the way the statute is set up, it's limited on what you can ask a child at that pretrial hearing. You can't get into the elements. You're just looking at whether or not they showed up and they gave a statement, and they had all the center was the right type of center, the interview was the right type of person, had the right 3 years or more experience. All these things have to be checked off. But the defense counsel is prohibited from going into the elements of at that part of the hearing. So when we get to a trial and she clams up, I object, I move to strike, and the judge makes a ruling finally that it's a question of fact for the jury to decide, and I'm saying, no, that's a legal issue. It goes back to those pretrial check marks that you now have shown. I've shown her at cross-examination to not be trustworthy, that she's lied on that video. You can only have 1 last time.
That's true, but at trial, she clams up in front of the jury, right?
Yes.
Okay.
On the forensic interview, she's not under oath, Your Honor. That's the other issue you have.
Let me see if I understand exactly what happened here. You had a pre-trial hearing on whether or not the forensic interview was going to be introduced,
Yes.
correct? And at that hearing, the trial judge watched the video. He saw what you described in that she first said, this house, took a break, come back, had a discussion with mom, came back, and that was the last time, came back after the discussion. So the judge was aware of this 2 last times, correct?
And I brought it to the court's attention. I said, what are you going to do if she doesn't answer any questions at trial, since I can't get into it now? What's going to be your remedy? He says, I'll take that back up if it happens. And that's exactly what happened.
But he was aware, the trial judge was aware that she testified at the,
I
or
believe
stated.
I believe the record will show that I did ask or submit to that an argument that she says 2 last times.
And even after hearing that, the trial judge, as you say, checked the box, trustworthy.
Correct.
Okay. Well, then, I don't see how your argument changed at trial then, that now it's not trustworthy. I'm losing that
Because
connection.
the second part of that last bit says, and the child must be available for cross-examination.
Okay.
I didn't have a chance to cross-examine her until we got to the trial. And so therefore, he has to then revisit that ruling based on how she testifies. And my argument to this court is that's the way the statute should be. If we're not allowed to cross-examine her on the elements at the pretrial hearing, then we have to be able to go back and then strike that forensic interview during the trial if the child does not testify under oath to at least something.
And your position is that clamming up at trial is not being available?
Correct, because it's like she wasn't even there because she didn't answer any questions about those elements. I need to move on to some other issues here, Your Honors. I appreciate the banner. I'll answer all the questions you want, and I could talk for a long time on this case, but
You got 20 minutes.
I understand.
Or actually,
I don't
guess
have many
16.
left right here. So the other thing I want to talk about on the forensic interview is, unlike Rosiska, defense counsel did not ask any questions on cross, and the only time the child was somewhat unsure on some answers was during the state's direct of her before the video came in, which is surprising because most prosecutors won't ask those types of questions. And so that defense counsel never got any questions out because they chose tactically not to ask any questions in that case. On issue 2, my client's statement being excluded, it really comes down to this. The officers in this case lied to my client repeatedly. We know the case law is there that officers are allowed to lie to suspects to try to get a confession or a statement from them. I have no problems with officers bending the truth or trying to get somebody to admit something. In this case, my client was in custody. He hadn't been to court yet, been in custody 3 or 4 days, hadn't had counsel appointed. They bring him down a day or two before his arraignment and start questioning him. And 45 minutes through, for almost nearly an hour, he denies ever doing anything to his daughter. I wouldn't do that, wouldn't do that, wouldn't do that. And then they started picking up the pace. You're going to face over 100 years, which potentially, depending on what he may be convicted of, potentially, but still that's a threat. But the biggest part was when my client repeatedly denied everything, Detective Webb says, I will tip our hand a bit here, a bit more. What if I told you that we had DNA semen on 2 articles of your daughter's clothing, her panties? As my client testified at the pretrial hearing on the motion to suppress, and again at trial, his mind just blew up. He was shook, shaken, scared. How do you fight DNA evidence? His initial reply after asking for a cigarette, and they gave it to him, was, I'm a chronic masturbator. I masturbate all the time. It could have gotten on the towels in the bathroom, put in the hamper, and had transfer of DNA, which can actually happen. There's case law on that, on transfer of DNA. But in this case, it was a blatant lie because they didn't even...
Let me ask you something. After your client said it was from masturbation,
Yes.
what trickery did the police use
The
to
second
get him to change his story?
The second detective in the room, and they kind of did a bad cop, good cop kind of guy. The second one says, that's the defense you're going to go with? Is that you're a chronic masturbator? Is that really what you want to stand in front of a jury and face going to life prison with? Is that? You need to do something to help us. We can only help you if you get truthful with us. We can only go to the DA and get assistance for you for a reduction in crime or time if you give us something more than that. You cannot live with that defense. And so, again, he would have never said anything about doing anything remotely close to his daughter without that primary threat of DNA, which they didn't even have the report back until December of that year. This interview was done in October and November. They didn't have the report back. It was sent off in July. And then the state refused to give that report to me until I had my pretrial motion to suppress his statement. And in the middle of the hearing, the prosecutor stands up and says, well, I've got the DNA report right here. And I says, how long have you had that? Are you sandbagging me? Because and he's like, I've only been on the case a month, Mr. Haas. I'm like, it doesn't matter. The state has control. And this was in October of 2021, and the report was dated December of 2020 from the TBI lab, showing no semen, no DNA on my client on her panties. I'll address the insufficient evidence when I come back.
The case law is abundant that the police can do exactly what they did. Have you cited any authority that says they cannot do what they did?
It goes to the level of deceit. The fact that they out and out lied about a piece of evidence, a specific piece of evidence. It wasn't that, what if we were to test your DNA and we have items from her clothing and we may find something, or there may be something there. That's a true hypothetical, which is what the state tried to argue at trial during my motion hearing, is that this was purely a hypothetical question. And my response is, it cannot be a hypothetical question when you particularly say 2 pieces of clothing on your daughter. If he just said, what if we found some of your DNA on some of her clothing that we've collected and sent off to the lab, I think that's a perfectly fine hypothetical. But when you go and say, we found your DNA, your semen, on 2 items of her clothing, her panties, that is a blatant lie intended to break a suspect.
Well, I'm going to ask you again, did you cite any authority in your brief that a blatant lie of that nature renders a confession involuntary?
I'd have to refer to my brief, and I'll try to answer that question when I come back for rebuttal.
Well, I mean, it's one thing to say it's a blatant lie. It's another thing to say that that makes a difference in the case, and to cite some authority that says it makes a difference in the case.
I understand Your Honor's question. I'll double-check my brief while the state's arguing, and I'll try to reply to that during the rebuttal. And I appreciate the court's question.
Thank you.
And I'll address the insufficient evidence when I come back.
I don't mean to interrupt you.
I'll answer questions all day long, Your Honor. Thank you.
Mr. Redding.
Good afternoon, Your Honors. Abigail Hornsby for the state.
I'm sorry, I called you the wrong name. Ms. Hornsby.
That's all right. I'll contain my argument primarily to the suppression issue and forensic interview as defense counsel did. However, I'm happy to address any questions the court has about other issues as well. First, the trial court properly analyzed the totality of the circumstances when it concluded that the defendant's statement to law enforcement was voluntary. Here, the court went through and analyzed the totality of the circumstances, as it must for a suppression issue of this nature, found that at the time of the interview, the defendant was neither particularly young nor elderly. He was extremely well-spoken, had some college education, and actually had personal experience with both detectives in this case. The defendant was advised of his Miranda rights. He confirmed that he understood them. He signed a waiver, and he expressed his desire to talk to the detectives, especially Detective Ramsey, who he had interacted with on a previous case and had this kind of personal relationship with Detective Ramsey. The court also noted that the interview was a total of around 2 hours. The officers gave the defendant multiple, 10-minute long smoke breaks, gave him drinks, allowed him to take a break really anytime he wanted. And around about 40 minutes in, I think, was the first break that they took. And then when they came back from that break, the defendants began to confess. So it's really not very far into this interview that the defendant starts confessing. And then around an hour and a half into this case, the interview happened before, there were 2 victims originally, and the interview happened at the very beginning before they severed the counts for the victims. So it addresses some of the issues with both victims. And then, but the first half that's recorded, the defendant they're questioning him about the victim in this case, and then they turn to the other victim for the remaining.
Is that the part of the recording that was not introduced at trial?
Yes, so that part, the detective had used a key fob recorder that didn't have a ton of space, I guess. And so around an hour and a half into the interview, the recording cut off and just ran out of space to keep recording. So the end of the other victim's interview was not the victim's interview, but about the other victim was not included. And as far as I'm aware, the state cut off before they kind of turned to the other victim, because obviously that would be problematic. But it was very delineated about, first we're addressing this victim, now we're addressing this victim. But the issues about undue influence and pressure, so here there were law enforcement did not explicitly lie to the defendant here. He was facing a very significant indictment with the other charges from the other victim. There would have been, I think, an additional 2 counts of rape, 2 more counts of incest, and a couple other counts as well, in addition to what he had with this victim. So he was facing a very, potentially very significant sentence. So the detective's comments about sentencing were, perhaps not precise, but not an explicit lie either.
What I remember reading in the briefs was at one point the detective, in response to a question from the defendant about how much time he was facing, said it might be up to 100 years.
Something along those lines.
Somewhere else said something like it may be up to 60 years.
I think he provided an example. I think the 60 years was about a recent defendant who he had been charged with similar things.
This defendant actually got 52 years,
Yes.
mostly with no parole.
Correct. But nonetheless, had all of his counts been stacked, it is possible. I think it comes out to around 100 years. But nonetheless, the defendant primarily is concerned about this hypothetical question that Detective Webb asked after, I believe it was after the first break.
Well, humor me for a moment. Let's assume it's not a hypothetical and they just told him they had this evidence. Is there
Sure.
any case law that says they can't do that?
No, there's not. I think, if you have, it remains a totality of the circumstances analysis, and it is very clear from Tennessee appellate courts that misrepresentation or lying by the police will not render a confession involuntary by itself. So
And
perhaps,
I'm sorry, but it seems like I have a memory as a former trial judge that there's an instruction about this too, that's given to juries sometimes in this situation, that they have to consider whether the defendant's will was overborne by this threat of, in this case, DNA semen. Do you know if that instruction was given or anything like that?
I am not sure if it was given in this case.
Are you aware of such an instruction?
It sounds familiar.
Okay, me too.
It sounds like something that would be given, but I'm not sure if it was given in this particular case. But nonetheless, this court and the Tennessee Supreme Court are both, it's not, unless it is to the point where it's overbearing the defendant's will and coercive, and in the totality of the circumstances, the defendant's will is overborne to the point where the confession is not voluntary, that's when it becomes a problem. It's not the misrepresentation by itself. So perhaps if you have, a defendant who's very vulnerable, has no experience with law enforcement, perhaps has some sort of mental illness, that clearly doesn't understand what's going on, isn't advised of Miranda, and then is told all of these things, perhaps then that would get to it. But that's not at all what we have here. And under the totality of the circumstances, the defendant's will was not overborne. And additionally, the defendant's confession did not even align with what the detective said. The detective said that, asked what if your semen was found on her underwear. And he, talked about being a compulsive masturbator, which really has no bearing on the actual offenses charged here. And then he said that when he finally admitted to any sort of sexual contact with the victim, it was that he performed oral sex on the victim, which obviously would not result in his DNA appearing on her clothing or his semen appearing on her clothing. So, if this was a case where the detective's statements had overborne his will, presumably he would have confessed in a way that kind of aligns with what the detectives had said. Turning next to the forensic interview, here the trial court appropriately analyzed all of the required statutory factors and concluded that the interview was trustworthy. So the forensic interview statute has this just long list of requirements, as I'm sure you are all aware. One of them requires this pretrial hearing, which the court held. It requires that the victim be available for cross-examination, and that is notably not part of the trustworthiness factors. It is a separate prong that's just kind of one of the requirements to get the forensic interview in, but it is not part of the analysis about whether or not the recording is trustworthy. When the court analyzed the trustworthiness factors, it went through each of the factors enumerated in the statute, noted that the victim was 10 years old and very articulate, and although she had difficulty talking about the allegations, she communicated them very well and articulated them in a graphic and detailed manner. The court found that she had no proof of motive to falsify or distort. The timing of the forensic interview was very soon after she told her mother. I believe she told her mother in the evening, and then the forensic interview took place in the afternoon of the following day. The court noted that the abuse was ongoing. The interviewer asked open-ended questions, which the victim was directly responsive to, and it also found that the equipment was capable of making an accurate recording, and just kind of, went straight down the list in the statute. And the fact that the victim couldn't recall certain details about the offenses when they got to trial did not mean that she wasn't available for cross-examination. To your point, Judge Ward, she answered the questions, she just didn't answer them in the way that the defense team perhaps wanted her to. But really, it provided the opportunity for the defendant to very thoroughly impeach her. There was some confusion in her mind about which time was the last time her father had abused her. But again, she was talking about ongoing abuse. At some points when he was living with them, she said that it was happening on a weekly basis for years, from when she was in kindergarten or first grade until she was around 10 years old. So it's not surprising that she might have a little bit of trouble recalling exactly which time her father tried to rape her was the last one. That is not surprising at all. And the defense counsel was able to highlight all of those inconsistencies during his cross-examination. And her cross-examination, I think, spanned around 15 pages of transcript. She was honest that she didn't recall certain details. She said when she testified at trial, she identified herself in the video. She said that what she said was true and accurate to the best of her recollection, and hit all of those required factors that are in the statute, and that's all that's required. As to the confrontation arguments, the Tennessee Supreme Court has held that as long as a child witness authenticates the recording and appears for cross-examination, there is no confrontation clause violation, and that's exactly what we have here. The victim authenticated the video, appeared for cross-examination, and although the fact that defense counsel was able to thoroughly impeach her and do a good job of impeaching her does not mean that she was not available for cross-examination, and it did not violate the defendant's confrontation rights.
So you disagree with counsel that a witness that clams up that doesn't meet the definition of an unavailable witness?
No, it does not. And she's not a witness who, is, I think perhaps it would be a different scenario when you have, an uncooperative witness who everybody realizes is just refusing to answer questions. Whereas here you have, she tried to answer the questions and she didn't remember. And it's not surprising that she didn't remember certain details because this is very traumatic abuse that happened when she was 10 years old.
She was 12?
I believe she was 12 at the time of trial, yes. And again, the results of the victims, even had it been true that she clammed up, that doesn't have any bearing on the trustworthiness of the forensic interview, because again, that factor under the statute is not part of the trustworthiness analysis. The trustworthiness goes to the forensic interview itself and analyzing the video, the recording, the allegations, and the trustworthiness of that. But notably, the cross-examination is not part of that consideration in the statute. And I think that's important here, that even if she was unavailable for cross-examination, that would be a problem, but not because the recording was untrustworthy. And then briefly address the sufficiency of the evidence. Here, the evidence is sufficient to support the defendant's convictions. For the defendant's rape of a child and incest convictions, they both kind of dealt with the same incident in the summer of 2020 when the victim was 10 years old. She told the interviewer that the defendant tried to put his penis inside of her at their new house. And although she was not sure whether it went inside her or not, she explicitly testified that it hurt. And so from this account, we can infer, at least the jury could have inferred at least slight penetration given her contention that it was painful. And that is enough to satisfy the elements of the statute. The statute defines sexual penetration as any intrusion, however slight, of any person's body into the victim's vagina. Similarly, the defendant's aggravated sexual battery conviction, there's ample evidence of unlawful sexual contact when the victim was under 13 years old in the forensic interview, and the defendant has not suggested otherwise. He hasn't really challenged any of the elements of aggravated sexual battery, notably. He has simply reiterated his complaints about the forensic interview and the victim's inconsistent statements. Excuse me, but this court considers all evidence in a sufficiency review, so even assuming that the forensic interview was improperly admitted, it would have no impact on this court's sufficiency analysis. And the court also does not reweigh or reevaluate the evidence. The jury heard the forensic interview, heard the defense very thoroughly impeach the victim about these inconsistencies about when the last time was, and it weighed it against the victim's forensic interview and made a credibility determination. And if this court has no additional questions, we ask that you affirm the convictions.
Thank you, ma'am.
Thank you.
No, sir. How much time we have left, Madam Clerk? 4 minutes, sir.
To address your issue, Judge Ward, about citing a case, State versus Smith, 933 Southwest 2nd 450 at 455-56, Tennessee Supreme Court, 1996. It says the critical question is whether the behavior of the state's law enforcement officials was such as to overbear the petitioner's will to resist and bring about confessions not freely self-determined. So it's cited in my brief on that issue, so there is citing material there. I need to focus a little bit of time on the insufficient evidence, Your Honor. The state even admits that my client's statement that they got to play in front of the jury did not match up to anything that the little girl alleged that her father did. So the only impact you really had was a shock factor to the state, to the jury, that her own father is admitting doing, to use the term from the other case, an evil act on his own daughter, which nobody should do. It didn't match up. So the statements didn't match up. If the forensic interview should not have come in because of the way the witness didn't testify, There's no DNA evidence because they were sent off to a lab. There's nothing there. This whole case started because his daughter was caught with porn on her phone at 10 by her mother while she was finishing her nightly phone call to her ex-husband, who they were trying to reconcile with, my client, when he was in Savannah, Tennessee at the rehab center where he was working, where he'd been out of the home for 2 solid years. He was kicked out of the house because of drug use and things going on. The wife kicked him out. They got divorced. He had to live with other people. He went to rehab and then started working at the rehab at the tail end, and they were trying to reconcile when he got clean, and every dollar from his paycheck went straight to her bank account, so that when he came home on this last event for the 4th of July weekend of 2020, she had to rent a car for him to be able to drive back from Savannah, Tennessee to Cott County, Tennessee to visit the family. He had no ability to get there. He was not around this girl very little for the last 2 years, so the continuous abuse is not really there. You talk about the proof on the rape of a child. That came from the back end of the interview where she said it happened at the new house, and he took her in there and tried to put it in, and it hurt. The forensic interviewer never asked a question, where was his clothes? Where were your clothes? Did he take them off? Did you take them off? Did he take off his own clothes? Did he lay you down somewhere? What did you see? Did you describe what he looked like? Did he have an erect penis or not? None of those questions were ever answered, and so therefore when I get to trial and I try to cross-examine her about these issues on the elements that are highly important, I can't even get her to answer, did you have clothes on or off? Who took the clothes off? So how do I even get to penetration or attempted penetration for the rape of a child for the sufficiency of evidence? It just doesn't add up when you look at all the evidence in this case. So, just kind of summarize things. One of my favorite authors is Michael Connelly, and he wrote The Lincoln Lawyer, if you know that movie. He has a fictional character for most of his novels, and his name is Detective Harry Bosch. He serves murders and serious crimes, cold cases even, and one of the books talks about him trying to solve a murder of a prostitute, somebody that we think of as on the low end of society, somebody that we might be a toss away. And one of his other detective buddies or friends says, why do you care so much about solving the murder of a prostitute? And his mantra was, everybody counts or nobody counts. So, to paraphrase it to this court and today's case, if we don't use the law to protect every accused in this type of case and make some teeth into the confrontation clause again under the Tennessee Constitution, the state constitution, does the law protect everybody or does it protect nobody? It has to protect everybody. That's where the scales of justice, blind justice, we have to protect everybody. It doesn't match up. I think this case should be reversed, and I ask you to reverse this case, Your Honor. Thank you.
Thank you, Mr. Haas. Thank you, Ms. Hornsby. Madam Clerk, does that conclude our docket for today? Okay. Just so that everyone is aware, I know we have 3 cases set for tomorrow. The second case, the Duncan matter, has been continued by orders of the court. Otherwise, we'll be back in the morning beginning at 9:30 for another good day of oral arguments. Thank you all.